for some legal perspective on the decision not to appeal the Stanley verdict and some of the arguments against it we've just heard. I'd like to bring in Ingrid Grant once again. She's a criminal defense lawyer and contributes to CBC News Network on a regular basis. She joins me here in Toronto. Ingrid, do you think this was the right decision?
Well, it's not exactly for me to say if it's the right decision. I haven't reviewed the entire trial transcript. I wasn't sitting there for the trial. But the Crown has done that and has made the decision that there wasn't a basis for an appeal here. The Crown's right to appeal a trial, especially a jury verdict, is really very limited. It is limited to questions of law. And what that means is, did the judge make any errors in his instructions to the jury about how they should approach the case or what law would be applied? Or if the judge made errors in things like the admissibility of evidence, so whether a particular piece of evidence should have gone in or should have been excluded. An error in something like that can be the basis for an appeal, only if the Crown can also show not just that there was an error, but that the result would not inevitably have been the same.
Right. Okay, that's an important point, and Deputy Attorney General made that point earlier today, and that's what Boushie's lawyer is arguing. The family lawyer is arguing, isn't he, that those two experts, should not have been allowed to testify, or their evidence should not have been allowed to have been heard by the jury.
Well, I wasn't entirely clear on what the counsel was referring to there, referring to defense experts, or whether he was talking about lay people who were permitted to give some evidence about this hang fire phenomenon. The main problem, it would seem, is that it doesn't appear that the Crown objected at the time to whatever it was that these witnesses were testifying to, whether they were experts who were allowed to offer an opinion or whether they were lay people who were just allowed to describe a phenomenon that they'd experienced. It would be very difficult for the Crown to now appeal the judge's decision to allow evidence if the Crown hadn't objected at the time.
Ah, I see. Okay, but could they still do it technically? Could they still say we were the ones that made the mistake?
It's possible, but it would be very, very difficult for the Crown to go to the Court of Appeal and say that a particular piece of evidence shouldn't have been allowed in, or that a witness shouldn't have been qualified as an expert if they didn't dispute it at the time. Incredibly difficult.
Okay, so what is open to the public then? If the Crown has made an error and they are the ones in charge of launching an appeal because the verdict didn't go in their direction, what is the family left with then?
Well, they're certainly free to advocate for any necessary inquiries if they feel that the investigation wasn't adequate, or that mistakes were made in the investigation, or even in the prosecution. They're free to advocate for that politically. But the public doesn't have a right to instigate an appeal, to launch an appeal themselves. The family, that's just not the system we have. Cases are prosecuted by the state, by the Crown, and that's the same with appeals.
Okay. Listen to what the Deputy Attorney General had to say today about those who are upset with the decision. Take a listen to this.
There is no evidence that anything other than the trial evidence and the judge's instructions guided them to their unanimous verdict. To presume that because a jury chose a particular result, they, all 12 of them, must have acted improperly, does them the greatest disservice. It hints at turning the justice system into a servant of an agenda instead of the means to determine whether a crime was proven. And it risks discouraging others from doing their duty in the future.
Okay, I apologize. That was the wrong clip. I want you to listen now to the correct clip, which is the Deputy Attorney General and what he had to say about those who are upset about today's decision.
I urge no one to be discouraged or distrust the system. We are all in this together and must be united against crime and in the search for justice. Complainants need to come forward when they have been wronged.
All right, undoubtedly, Ingrid, a lot of people will fall on skeptical ears tonight.
Well, yes, people who who knew Mr. Boushie, people in his community, they are upset. They have concerns about what happened here. They have some concerns about how it was investigated, and that's all fine. They're free to pursue those avenues. The problem, though, is that so often we hear the general public every time, and you've heard me say this before, Carol, every time someone is acquitted, it's talked about as if it's a failure, as if there's been a failure in the system somewhere. Why? Because it can only be based on the assumption that anyone who's accused must be guilty. And that's not true. And we know that's not true. And the fact is, we have a system where 12 basically random members from the community made this decision. This wasn't a judge appointed on high. This was 12 members of the community who had to come to a unanimous verdict. And the idea that all 12 of them relied on some improper way of thinking and that wouldn't come to light, it doesn't seem likely.
It's not only the Indigenous community, though, is it, who has a problem with our system. There are many women who have been victimized by sexual assault, so female Canadians, Black Canadians, marginalized Canadians who have dealt with the system. I mean, can that many people be wrong? I mean, does there have to be something looked at when so many people complain about it?
There is not a problem in this country that it is too hard to convict people, especially vulnerable people. If anything, the problem is that it's too easy, that there isn't enough help out there, there isn't enough legal aid, that people who have mental health issues, people suffer racism in the justice system, and I'm talking about the accused people. So, no. Is there a problem that it's too easy for people to be acquitted? No, it's not. We have a system that is set up this way for a reason. Proof of guilt has to be beyond a reasonable doubt, and in the case of a jury trial, it has to be a unanimous decision by 12 jurors, and that's the way it ought to be.
All right. Ingrid Grant, criminal defense lawyer, joining me in Toronto tonight. Ingrid, thank you.
Thank you.